Greetings and welcome to When There Is No Money. This is a book from Byron Beers, and let's go over the table of contents here. Greetings to everyone, and here we go. Table of contents, introduction. We'll go over the United States in its national capacity, the money changers, and then a summary. Certainly no nation ever before abandoned to the avarice and jugglings of private individuals to regulate, according to their own interests, the quantum of circulating medium for the nation, to inflate by deluges of paper the nominal prices of property, and then to buy up that property. Yet this is what has been done and will be done. That was from Thomas Jefferson to William C. Rives in 1819. So, wise words that seem to ring true still today, as he said, will be done. So, let's continue. Emphasis was added throughout this writing by underlining, but the quoted passages are bolded. So, this was a quote. So, the treatise, Where There Is No Money, When There Is No Money. Introduction. And the Lord shall bring thee into Egypt again with ships, by the way whereof I spoke unto thee. Thou shalt it not no more, not more again, and there ye shall be sold unto your enemies, for bondmen and bondwomen, and no man shall buy you. And that's from Deuteronomy. And I think what we're saying here is, thou shalt see it not more again, and there ye shall be sold. For thus saith the Lord, ye have sold yourselves for nothing, and ye shall be redeemed without money. And in Proverbs we find, be not thou one of those who are sureties for debts. And Proverbs tells us the borrower is servant to the lender. And in Kings, they are told to get rid of the debt, and live thou and thy children on the rest. And in John, the more famous line, and ye shall know the truth, and the truth shall make ye free, is a directive to never be in bondage to any man. Let us keep in mind that government is instituted for the benefit of people. It would be ridiculous to assume any government was established for the demise of life, liberty, or happiness of the people who created government. This treatise will look at the issues concerning money, with emphasis on what happens when a government or an associated corporation issues a paper medium of exchange. It has been well established that the Constitution for the United States, second here, that's gracious. Lost the chat. There we go. It has been well established that the Constitution for the United States delegates to Congress the authority to coin money and establish the value thereof, and the authority to borrow money on the credit of the United States. The first reference regarding coining money and establishing the value had to do with metallic money of intrinsic value, and did not allow for the use of paper money. Emphasis is added in the following quotes throughout this writing. So here we have standard money. Money made of a metal that has utility and value apart from its use as a unit of monetary exchange. That's from the Random House Dictionary of the English Language, 1967. Paper money and tender laws were such notorious and flagrant evils that it was deemed unnecessary to prohibit them expressly and by name. Wow. That's from 1827 in Ogden versus Sanders. So, such notorious and flagrant evils. It was declared in every state whose debates on adopting the Constitution are reported that paper money was to be put an end to. For several years, in the direst direst needs of the country, Congress not only never asserted any right to make a Treasury note legal tender, but, by the nature of its legislation, had indicated that it had no power to even materially debase the coin of the Republic or stamp it with false and arbitrary values. During these years, this court has spoken of the legal tender as pernicious, and it has pronounced that paper power, a trust delegated to Congress to maintain a pure metallic standard, pernicious. This is applying to pecuniary. No, pernicious. Okay, never mind. Not only Mr. Madison thought Congress had no power to make paper a tender, but Mr. Webster thought so. And the power has been frequently denied in Congress, and prior to the law in question, never contended for. Those are legal tender cases from 1870. So again, the legal tender for, this is of course for the pronounced money power, a trust delegated to Congress to maintain a pure metallic standard. So there is an issue here with the paper currency. When it comes to money and the government of the United States, there are two elements to consider. The one is to coin money, that is, to mint or fashion the gold or silver of the people into coins with a stamped weight or value. Also, foreign metallic coins serve as money, and Congress may oversee their use as to proper weight and value. In neither case does Congress create money. It only oversees the coining of money of intrinsic value thereof. The other element of money comes in the form of borrowing. This method is not as obvious to the casual observer and will be more fully explored later. Next, we will look at the sources of revenue delegated to the government of the United States. There are two sources of revenue. This is emphasis by the author. There are two sources of revenue which are essentially the right of the general government, that of imposing duties, and that of borrowing money on the credit of the nation. The safety of the whole depends upon the free and undistributed exercise of these powers, undisturbed exercise of these powers. In peace, the first, that is imposing duties, is necessary to revenue. In war, the second is vital to defense, borrowing money on the credit of the nation. If these powers and rights are not guarded and preserved, the functions and purposes of the Union will be suspended and destroyed. That was Weston versus the City Council of Charleston, 1829. In times of peace, the government was to function on revenue from duties or customs on imports. In times of war, with war meaning a defensive act if America were attacked, the government of the United States may need to borrow money. One should also remember that the means for men to defend the American states was the militias in each of the several states. Borrowing during war or emergency was not meant for fighting wars abroad to build a United States empire. Who would have known? Greetings to Tara and anyone else in the chat that's just arrived. And please hit the like so we make sure to get the notifications out there. I notice they've been somewhat slim lately. Let's proceed. When it came to borrowing money, the government of the United States could issue bonds to lenders who have dollars of intrinsic value to loan. The key is intrinsic value. Dollars of intrinsic value. The bonds would represent a claim upon the government of the United States to the holder of the bond. There are obvious dangers in this method of borrowing, since a debtor is subservient to a lender. If a government is established for the good of the people or states that created it, then how can the same government be subservient to foreign creditors? The creditors, wielding such potential influence over the affairs of such a debtor government, could realistically alter the actions of government to the advantage of creditors. A true constitutional republican form of government would need to rely on revenue from customs to repay the bondholders, as described in the Weston quote above. Before we look at a second form of borrowing, let us look at one of the many comments made about the government becoming a debtor to the bondholders for the purpose of creating a paper currency based on debt. This is known as a funding system. Judge Henry Clay Dean wrote a 512-page book, Crimes of the Civil War and Curse of the Funding System, published in 1868, in which he explains a funding system, the evils it produces, and its long-lasting detrimental effects. Here are a few quotes from his book. Funding systems are always based upon public debts for the purpose of transferring the control of the government into the hands of the bondholders as security for their obligations. Whilst the funding system lasts, the government is administered in the interest of the bondholders, who control its legislation. Every independent government is jealous of the rival power of those moneyed oligarchies, which dethrone monarchies and destroy governments by the transfer of the debt to strangers, who thereby secure a powerful and dangerous influence in the government and work its destruction. There cannot be a more startling fact presented to any people than this, that in the richest gold country upon earth, there is not one gold dollar in ordinary circulation, notwithstanding the Constitution of the United States has made gold and silver the only legal tender for the payment of debts. Mr. Clay is saying mere paper with the words of promises to pay cannot by any construction be considered money. Promises to pay are credits, not money. Henry Dean Clay continues, money is the evidence of wealth, held to represent values. Credit is the evidence of poverty, held to represent indebtedness. Money has a positive value, fixed and stamped upon it by law, which, when used in commerce, commands its specific value. Notes or credits are in themselves nothing but the promises dependent upon the solvency or insolvency of others for their value. So you have a third-party counterparty risk here. Money is the standard value of commerce, by which it is measured and controlled. Credit is a beggar upon commerce, for time to pay goods and taken upon in advance of payment. Credit is just as much money as the shadow of a house is a house, its picture, nothing more. Money is payment, beyond which no inquiry is made. Credit is the promise of money, without the payment of which it is entirely worthless. There is another form of borrowing without the need for bonds or foreign lenders. That is, turning the constitutional power to borrow into a currency or form of money. How does this work? All right, well, let's look into this. And jump over to the chat. There we go. Bill Thomas says, pennies have been made with zinc for decades now. Even coins can be debased. Well, in 1964 was the last year they were minting our silver coinage with actual silver. Since then, the dimes and quarters look just the same, but they're copper inside, and not silver at all. So it looks the same, but it's not anymore. And they were being spent alongside true silver coins at one point. It's a real amazing thing that people could just sit there and have an actual debased currency right alongside being spent with true value, intrinsic value money, and not being a big deal. It seems, steel pennies during World War II also were used, I guess, to get more of the copper used for the war effort. Again, borrowing from the people, because remember, the coins are done with the people's metals. And that's one other... Our money are not Federal Reserve notes; those are debt instruments, right? They can be used for paying debts. So it's not intrinsic wealth, as we're reading here. Money is a payment beyond which no inquiry is made. So it's a big difference without a promise. A promise without the payment of which is entirely worthless. So as long as that Federal Reserve note works, it's all good. But how does it work? It should be pointed out that no mere paper currency was authorized by the Constitution, yet that is what we find in circulation today. The point to be made here is that if a paper currency is going to be used, there may be a better alternative. To understand this maneuver, we need a little background on forms of government. It is believed by some that a national government is deemed to be the superior authority over its citizens or residents. A national government claims to be the holder of sovereignty and could potentially claim to have an interest in the assets of its citizens or subjects, including their labor and their property. Oh, these are a few of the reasons the people of the several states did not ratify a constitution establishing a national government. I refer to my book, America, National or Federal. So shout out for Byron Beers. We'll look at that book and see if we can possibly look at that on a future stream. While these assets of a nation could be used as surety for the bonds delivered to the creditors, these same assets could also be used to back a paper currency issued directly by the Treasury. In effect, the issuance of a national paper currency is in fact a form of borrowing from the people, in that the people's labor and property are the source of credit or value backing the circulating paper currency of the Treasury. Think about that. The people's labor and property are the source of the credit. Interesting. When the government of the United States issued a paper currency during the Civil War era, causing great debates in courts and elsewhere, the legal tender notes were said to be a mortgage on the property of the nation. So this is, let's see here. But it has been claimed to be a proper regulation of commerce for Congress to provide a uniform national currency, and that these legal tender notes were, in effect, a mortgage on the whole property of the nation, and therefore the best secured and most uniform currency the nation could have. Although, in truth, the security for this or any national debt is exactly the extent to which the people will consent to contribute through taxation to its payment. Which reminds me of some of the words from Frederick Douglass. He says, find out the amount of injustices society will tolerate, and you'll see the exact amount of tyranny that'll be described, or something to that effect. At the time of the Great Depression and bank emergency legislation in the 1930s, we find the following quote from the Congressional Record. It is from the Congressional Record from the March 9th, 1933 Act. The money will be worth 100 cents on the dollar because it is backed by the credit of the nation. It will represent a mortgage on all the homes and other property of all the people in the nation. Right from your Congressional Record. However, the question is to be asked is the government actually borrowing standard dollars of intrinsic value, gold or silver? Or is it in effect converting the credit of the nation into a paper currency? Perhaps there is in fact no borrowing occurring, only the illusion of borrowing. If there is no actual borrowing occurring from outside lenders, then there certainly is no mortgage on all the homes and other property of the people. In fact, the lenders would be the people, and the government as borrower would be a debtor to the people who have knowingly or not provided the value for the currency in circulation. Since there is no gold or silver backing the currency in modern times, there would be no redemption of the paper money. The following quote from the Perry case illustrates this point. The Perry case is one of many discussing the destruction that has so often followed when a government proclaims a paper currency as legal tender. It is a power which cannot tend to beneficial results, because the paper of the government derives its value from the confidence of the people, which is the basis of its credit. And this confidence is not a creature of compulsory legislation. Occasions have heretofore occurred, as in 1812, in which, if the exercise of it was desirable at any time, it was expedient then. But Congress has never before claimed the right to substitute its own paper for gold and silver in the business transactions of the people. The object is really to borrow money from the people by forcing them to use government paper in business transactions. And it was supposed the validity of the provision would be rested not on the power to coin, but the power to borrow. For this is what the transaction was in truth designed to accomplish, though we think it can be shown that it does not tend to do so. The currency of the country needs no aid from Congress. If the government under this clause can make its own paper a legal tender, then it can the bonds of New York City or state, or the paper of the New York banks, or Arkansas bonds, or the paper of any private association or individual. It is incredible that such a monstrous stretch of power can gravely be claimed for a government like ours. Wow. That's for the respondents in the Perry case. This would appear to be a good place to insert another element necessary to better understand the foundation for the issuance of paper, money, and the power of borrowing. This discussion will eventually lead to a reason why the government of the United States could not issue such currency or legal tender earlier in its history, and why at this time, during and after the Civil War, the government believed it could issue a paper currency. All right, so now we're getting to section 1 here of the United States in its national capacity. Let's jump over here to the chat. All right, got some people in here. And Sir James Allen Cooper, mind-boggling to me, the people have been programmed to be surety to debt. Indeed, this is going back to 1933. This is nothing new. Yeah, it took my program about 16 months to understand that, huh? Yeah, it takes a little bit of a real reframing of the way things are originally presented to us. So, section 1 here, the United States in its national capacity. The government of the United States is said to function in two characters, one federal and the other national. As a federal government, those serving under the Constitution are restricted to expressly delegated powers. It has been said that the same government has expanded powers over the District of Columbia, where it functions as a national government. As a national government, those serving in such a capacity are said to function in a sovereign capacity and are not limited to expressly delegated powers, but are to adhere to the restrictions contained in the Constitution. Therefore, it has been said that the government of the United States could issue a paper currency for the district, but it could not do so with respect to the several states of America. The contract was made in the District of Columbia, was to be there performed, and respected real property in Washington. Within this district, Congress has power to exercise exclusive legislation in all cases whatsoever. Oh, geez. That's from Article 1, Section 8. These terms unquestionably include the power to make Treasury notes legal tender for all debts. 1869. Whether the statements made above in Willard were proper or not, that is the belief that succeeded in opening the door to paper money. What was then necessary to expand the use of paper currency was to get the states and the people to have a national political character, as though they were within the district, by using legal fictions. Wow. Another point that should be included is that the national character of the government was said to be the victor of the Civil War and conqueror of the states, or at least the Confederate states that had left the Union. The rights of a conqueror are found in the writings on the law of nations and international law and policy. The following quote is given to show a few of the issues addressed with respect to conquest. The people of the insurgent states under the Confederate government were, in legal contemplation, substantially in the same condition as inhabitants of districts of a country occupied and controlled by an invading belligerent. Wow. The rules which would apply in the former case would apply in the latter, and, as in the former case, the people must be regarded as subjects of a foreign power, and contracts among them to be interpreted and enforced with reference to the conditions imposed by the conqueror. So, in the latter case, the inhabitants must be regarded as under the authority of the insurgent belligerent power actually established as the government of the country, and the contracts made with them must be interpreted and enforced with reference to the condition of things created by the acts of the governing power. Wow. That's 1868, the Thorington versus Smith. In my research, I have not found a treaty of peace concerning the Civil War that would put an end to the war and emergency policy and statutes related to this era. The many alterations that have occurred in America starting with the Civil War are the result of the conditions imposed by the conqueror, while constitutional government had little leeway in how it could act. The new government format for the new nation following the Civil War did things that would have been considered contrary to the Constitution. In 1869, as expressed in the Willard case, we find the remarkable statement that goes against earlier Supreme Court decisions. Congress has the power to make Treasury notes legal tender for all debts in the district. Wow. Really getting down to the District here of Columbia being the seat of the national government and the federal government being the one that's delegated powers through the Constitution. There's more I would like to say on the subject of war powers, and the rights of a conqueror, but that will be covered in another writing, as the object here is to look at the source of credit, or value, behind the paper money now in circulation, known as Federal Reserve notes. Before moving on, let me say the main source or only source of power and authority is in God or his creatures as living, breathing men and women. It is the use of fictions that may cause the ignorant or unknowing to think conquerors, governments, or corporations possess real power. It is also relevant here to bring in another fact, that is, a new citizenship was developed by Congress via the 14th Amendment and prior legislative acts designed for those who had been in a condition of slavery. The new citizenship was a national political citizenship, corresponding to the character of the government over the district and with the addition of a sovereign power from conquest. It is the concept of allegiance being owed to a conquering sovereign in exchange for protection that causes the labor or property of the citizens to be available as surety on government borrowing and subject to numerous administrative regulations. Ex parte State of Virginia 100 U.S. 399 is one example that shows the 14th Amendment recognized, if it did not create, a national citizenship as contradistinguished from that of the states. Again, I would refer you to the book America, National or Federal, for more information on the subject regarding nationalism. In essence, the government of the United States, through its expanded powers over the district as a conqueror or sovereign power, brought in a new citizen subject owing allegiance to this new nation. This new nation gave the district a new preeminence, much like Rome was for the Roman Empire. The acquired territories were part of the new nation in a geographical sense. In a political sense, the new nation added a classification for U.S. citizens subject to the jurisdiction of the United States in its national character. The several states of America, each having a republican form of government, took on a new national character to fit the new design for the new nation, where the states became more like municipal corporations, being a political corporate entity as represented by the names State of Virginia, State of New York, etc. So the several states took on a new name as they became more like municipal corporations. Now, returning to the topic of money, we can see how it could be said time and time again that Congress possessed no authority for creating a paper currency, and then after the Civil War, establishing a paper currency, followed by incorporating national banks, circulating notes as currency, ending with a national centralized system with the Federal Reserve notes. But the question remains, who is really backing the paper money? Who is the creditor? And who is the debtor? In the Knox case of 1871 gives us some insight into paper currency, where the court was discussing the paper legal tender legislation. If Congress can exercise a power conferred by the Constitution, then the means which it selects are constitutional, whatever may be the opinion of the court of its practical wisdom, because the decision, whether practically conducive to the end proposed, is a political and administrative question, not a judicial one. Wow. That statement is very important for understanding how it could be that everyone knew Congress had no authority to make paper a legal tender until the Civil War era, when suddenly, although other tricks were involved like loading the Supreme Court with the right people, it is said this is not now a judicial question. It is not a question of law, but rather it is a political and administrative question. Those things that are political in their character are things that concern relations between the people and their sovereign. And that's American Insurance Company, bales of cotton. A major alteration occurred, allowing governments, more than ever, to assert themselves as masters over subject citizens. The evident meaning of these words, subject to the jurisdiction thereof in the 14th Amendment, is not merely subject in some respects or degree to the jurisdiction of the United States, but completely subject to their political jurisdiction, and owing them direct and immediate allegiance. To be a citizen of the United States is a political privilege. 1884, Elks versus Wilkins. There are several other questions also which may arise under our form of government that are not properly of judicial cognizance. They originate in political matters, extend to political objects. This is a most important point for many reasons involving many issues. It should be noted the government of the United States did not have a domestic or general jurisdiction within the several states. The appearance of expanded authority is a result of this political jurisdiction. It should also be noted there is a presumption that original law or constitutional judicial power does not involve itself with political questions. If government is acting as a sovereign political superior over things under its control, or as an agent for some other group or entity claiming such rights, then it is deemed that the superior political authority may dictate policy on various topics that are not a matter of law and not proper subjects for original judicial courts of law. Hence, what the law is at times of little avail, since most things will be viewed as political questions and are to be based on new theories, principles, and policies. My study shows, however, that your status, or whether or not you are subject to a particular authority, is voluntary. Next, we will return to the Knox case. All right, before we get to the Knox case, let's jump over here to the chat and make sure we're all caught up. Looks like we're caught up with that. Let's proceed. If the government needed gold and it was in possession of A, it could take it from him, and they could take his personal service against his will, or could batter down his house if it stood in the say of military operations. If A had said, I owe this gold to B, and am on my way to pay him my debt, the officers of the government could accompany him to his creditor, and when payment was made, seize it from him. What difference does it make whether that was the form in which it was done, or whether it was taken from A, and there was furnished him a certificate that the money belonging to B and intended for him was taken by the government, which would be responsible to B for its payment. Wow. So there you go. If government needed gold and it was in the possession of A, the government could take it from him as they could take his personal service against his will, or could batter down his house if it stood in the say of military operations. If A had said, I owe it to B, and I'm on my way to pay him my debt, they could go to the creditor and take it from the creditor, or they could just give him a certificate that says that they would be responsible to pay B for the payment. Wow. Small consolation for your gold. We should understand the Attorney General is speaking of extraordinary powers for government, as mentioned earlier, to take one's personal service or gold. This sounds rather feudalistic or even dictatorial, and you may rightly disagree with his statement. However, that is the nature of sovereign political authority used to build empires. If the political sovereign authority takes something from you, like gold, and gives in its place a paper, who is the debtor? Who is the party responsible to make payment? The government or whoever took the gold. In the Knox case, the scenario described would appear to utilize paper in the nature of money that is redeemable for gold if the certificate could be presented to the government for its payment. This would indicate there were outside lenders providing standard money of intrinsic value. See, when they seize it and give them certificates in replacement for something of intrinsic value. So what happened in 1933? Jump over here to the chat before we go back. Resident is a nasty word. Yes, the Little Red Book of Elementary Law, 1939, Walter Smith, page 12, member of a state. Yeah, and that res part of the resident is another affected by the property. And under that jurisdiction, I believe, also implies. Yeah, good catch there. Says you have two different status. Read it. Good book. Yeah, definitely check that out. Walter Smith. Will do. That'll have to be on the list. So what happened in 1933? Did the people and corporations turn in their gold? While there have been times when paper currency was redeemable for lawful dollars, being gold or silver, there are times when paper is not redeemable. Is theft allowed or lawful for anyone, anywhere? No. If a government is using the value by hypothecating the labor or property of the people of the nation and not paying you directly for your contribution, or there is no means to pay you lawful dollars of intrinsic value, then there must be a means of settling debts to adjust the accounts. Sometimes this is referred to as an exemption. The Indiana Supreme Court also discussed the legal tender acts of Congress and found them unconstitutional, which they are strictly by law. This evidently is not the case from a political perspective if one assumes the national character of the government, as over the district, was the victor, conqueror, and sovereign authority. In another aspect, it enables the government to make, by indirection, forced loans as actual, if not as oppressive as those of Charles I, as they are made without interest, against the will of the lender, and without repayment of but a part of the principal. Thus, in the case, as an example, the government desires Thayer to loan it $500. Thayer expresses his inability or unwillingness to spare the money. The government then goes to Hedges and Klager and says to them, you owe Thayer $500, which you are about to pay him. The government wants that money, but he will not loan it. You pay it to the government, and it will give you a piece of paper which will compel him to take of you instead of the money contracted for in payment of the debt. When a government uses a paper currency, it is equivalent to a loan from the people. It is through the use of paper money that the issuer can obtain everything necessary for himself or itself without surrendering anything of comparable value in exchange. However, I contend the issuer does have a moral obligation, in addition to a legal one, to those who provide the value or assets backing the paper currency. If we look at the same scenario from another perspective, whereby the people or property of the nation are the surety for the debts of a government if it borrows standard money of intrinsic value, standard money, as we saw in the beginning, the metallic monies of intrinsic value, then the surety has a claim against the principal debtor. An example here, the government. The people would be the creditors and the government the debtor to the people. Debtors are also principal and surety. The principal debtor is bound as between him and his surety to pay the whole debt. And if the surety pay it, he will be entitled to recover against the principal. Wow. And that's from Bouvier's Law Dictionary, 1856. The debtors are also principal and surety. The principal debtor is bound as between him and his surety to pay the whole debt. And if the surety pay it, he will be entitled to recover against the principal. The following is a scenario to help one understand the advantages for the issuer of paper currency. And we're on to the money changers. House Joint Resolution 192, indeed. And I think I even went over that in one of these live streams. If not, that's another good one to go through. Also, the Civil Rights Act, which is right around from the same time, is another good one to go over. But I think we're kind of we're getting pretty late in the stream here. I don't know if you guys would want to just carry on part 2, because we can finish the book in one more part here, and that way can kind of digest about where we've gotten to this far. And then we'll get on to the next part about the money changers, and then the summary here. Remedy is always there, my people. And I'll say this one thing that we saw in here that was probably the most important thing to take away from this here. And let me get back up to it here. Geez. I'll find it. Let's see here. I think it's further up here. Oh well. Anyways, we can always rewatch the stream, but there was some a really good line here too. It was let's see here. Yep. The kind of the political perspective here, and the political questions and administrative questions instead of judicial questions is one way they've taken it out of the whole lawful structure here with the paper currency, as you see. And I think it's yeah, no, it was way up here. Let me see if I get it. It's a great parting word. If I could find it, it'd be worth waiting for here, because I think it's good to leave with some of the more lingering questions here. See here. Yeah, well, good to look through this here and going backwards through it. Yeah, well, it is use of fictions that may cause the ignorant or unknowing to think conquerors, governments, or corporations possess real power. Is one part of it, and ended with another one here. You know what? I could find it a little bit quicker searching, but I don't know if this search is here. Give me just a moment here, and we'll see if we can do a quick search here. Let's see here. Page 8. Let's see if it's page 8. Oh, okay. It was back here a bit. All right, so although in truth the security for this or any national debt is exactly the extent to which the people will consent to contribute through taxation to its payment. So this comes from the Knox versus Lee in 1871. The security for this or any national debt, The security for the national debt is exactly the extent to which the people will consent to contribute through taxation to its payment. Almost poetic. And I think that's a good one to leave it with at that. Let's catch up with the chat here. Video recently about the copper pennies, 82 and older, 83. Yeah, they're still not pure copper. I think they still have a little bit of zinc in them. 95% copper, I believe. By the way, we never had pennies in this country. We have cents. Pennies are British. Indeed. Yes, it's all spiritual, and that's where the foundations of all this comes from, and the true power and the consent. Again, it's the law is supposed to be the rule of right, and to do right is to be in good standing. So yeah, appreciate you all being here and to go through this. We'll continue here with part 2 next time, and let's look here at the table of contents because they gave us a nice little outline of what we're going to be seeing next time. We got the money changers and then the summary. So this will be done rather quickly next time, but a lot to consider and a lot to digest from this. So once again, I'd like to thank you all for coming in while we explore When There Is No Money from the author Byron Beers. And I'd like to salute you all for going in through this learning experience here, and I hope to see you all on the next one. Peace out.